Hey, how's it going?
Good, thank you. Went out there.
Yeah, it is. Not used to it. I think the last time we had rain was, I don't know,
It's been a while. Yes.
early summer. It feels like forever ago.
Jennifer, do I have time to get my car? Where's my car? Can I get my glasses?
Yeah, 1 minute.
I've got 6 o'clock on the board.
Darlene had to go grab her glasses.
You can start whenever you're ready.
Okay, we'll let her
This conference
run
will
back
now
in.
be recorded.
So we're just giving it 1 minute for Darlene to grab her glasses so that everyone's all set and all ready. Okay, it is 6:01 p.m. on August 20th, 2025. This is the Zoning Board of Appeals for the town of Belchertown. Meeting on our agenda tonight is the application from Robert J. Berry appealing the decision of the building commissioner declining the building permit due to the land not having legal road frontage necessary for a building lot at 240 Munsell Street, also known as map 214, parcel 1, zoned primary agricultural. My name is Jennifer Sharrow. I am the board chair. Tonight with me are Darlene Silva and Wayne Versace as voting members of the board. What is going to happen tonight is first I am going to read into the record the application and then supporting documents which have been submitted both by the applicant and by various other boards within the town. After all the documents are read into the record, we'll open the public portion of the meeting. We will then ask the applicant or his representative to speak and present what's going to happen at the meeting. If there's anyone else here, first we ask you to stand and introduce yourself, who you are, where you're from, like where you live, and kind of how you're related if you're not in a butter or the applicant. And then anything should be addressed to the board. We don't want anyone addressing themselves from the audience. So and we ask that everyone remain on topic to answer questions that may come up. We will then close the public portion of the hearing, and then we will discuss amongst ourselves. We might have additional questions of the applicant, and then we will kind of make our decision from there. So that's kind of how tonight is going to go. So I am going to start by reading everything into the record. It's not going to be every single thing word for word, but I'll make note where I'm kind of summarizing what's happening. So the application was filed on July 10th, 2025 by Robert Berry. The address of the area, the plot in question is 240 Munsell Street, also known as map 214, parcel 1. It is the appeal of the building inspector. We are missing any kind of description of the frontage, depth, setback requirements. What was submitted and is listed here is a letter of denial from the building inspector, the assessor's information card, copy of the deed, copy of a land court decision, copy of another quitclaim deed, and a plot plan. I will read into record the decision here, which is dated June 10th, 2025, from the Director of Inspection Services. It reads, on June 28th, 2024, you were issued a foundation-only permit number 26034 for the parcel of land located at map 214, lot 1, Munsell Street. The permit was issued under section R 106.3.3, phased approval of the 2015 International Residential Code. The holder of such permit for the foundation or other parts of the build or structure shall proceed at the holder's own risk with the building operation and without the assurance that a permit for the entire structure will be granted. Based on information provided by the planning office, the parcel of land does not have legal road frontage necessary for a buildable lot. Therefore, a full building permit cannot be issued and is denied at this time. Respectfully, Paul Adsma, Building Commissioner. Next, we have a deed dated March 21st, 1990, that is transferring the land of William Farmer III to the town of Belchertown, a certain plot of land to construct, install, and forever maintain a town way, and then it provides a description of that land. Next is a deed of William Farmer to William Farmer. Another kind of parcel of land. That land is described. This deed is dated March 20th, 1981. Next is another deed from William Farmer III to Sunrise Properties, Inc. Describes another plot of land. This is dated November 26th, 2003. Next, we have another deed from Marcel Nunes to Robert Berry. Describes, well, it says Exhibit A, which should, it's generally a description of the land, but it's a deed. And I think we're missing the second page for the date. Next, we have a plan of the layout of Munsell Street, dated August 14th, 1985. Another plan of land with the layout, dated 1985. The property description from the assessors, what looks like the assessors. Land court. Decision. Dated October 31st, 1975. I believe this is the same deed from 1990. Another land court decision from April 1974. Building permit signature page. And then a map that is undated and not otherwise documented, which appears to show Munsell Street and the parcel of land in question. So those are the documents that were submitted together with the application. I have a letter from the planning board dated August 13th, 2025 regarding the appeal of the building permit for Robert Berry at Munsell Street. The letter states, "This is in response to your request for comment on the appeal of the building commissioner's denial of a building permit for Robert Berry on a parcel near Munsell Street. The planning board reviewed the petition from Mr. Berry and discussed issues around it at their August 12th meeting. There are some clarifications and additional information they point out. First, the plan that was included in the petition shows a subdivision approval not required, A&R plan, that was denied by the planning board on May 13th, 2025, and not subsequently appealed, so it is immaterial to this situation. The subject is only the existing parcel map 214, lot 1, not the other parcels owned by Mr. Berry. Second, parcel 214-1 has no legal frontage on, quote, a public way or a way which the clerk of the city or town certifies is maintained and used as a public way, or B, a way shown on a plan theretofore approved and endorsed in accordance with subdivision control law, or C, a way in existence when the subdivision control law became effective in the city or town in which the land lies, having, in the opinion of the planning board, sufficient width, suitable grades, and adequate construction to provide for the needs of vehicular traffic in relation to the proposed use of the land abutting thereon and served thereby, and for the installation of municipal services to serve such land and the buildings erected or to be erected thereon," which comes from NGL Chapter 41, Section 81L in part. Third, the status of frontage on this property has been fully adjudicated, establishing that Munsell Street does not provide frontage for this parcel. In prior litigation, 96 Mass Appeals Court 314 determined that prior erroneous decisions do not bind the subsequent boards to perpetuating such errors. Specifically, in this case, when an earlier planning board endorsed the A&R creating parcel 214-1, the court ruled that the planning board was within their rights to act on the A&R and that the denial of the A&R was correct because the land in question has no frontage. The court noted that collateral estoppel did not apply because the circumstances having changed, i.e. different planning board, different appellant, town meeting action that definitively ended the public way, and the discontinued portion having been included in the Oasis Drive Homeowners Association's open space parcel, thus establishing that the planning board had the right to act on the A&R application that had been appealed. Based on there being no frontage on the parcel in question, map 214 lot 1, the planning board recommends that the ZBA not grant the appeal and not overturn the building commissioner's denial of the building permit at this parcel. Not upholding the denial of the building permit would set the precedent that could entirely undermine our zoning bylaw by ignoring its requirements. Attached to that letter are notes regarding the A&R denial on February 24th, 2015, and subsequent appeal, prepared for the Select Board on October 26th, 2017. Additionally attached is the Mass Appeals Court decision of 2020, found publicly at 96 Mass Appeals Court 314. There is additionally attached to this letter an easement in favor of the land to the west of petitioner's property, which is recorded in the Hampshire Registry of Deeds at book 09798, page 73, and dated April 28th, 2009. I'm not going to read all of those documents into the record, especially the court case is fairly significant. But it is a matter of public record, as is the recorded easement. There is additionally a memorandum from the Director of Public Works dated August 19th, 2025, that reads, "The Department of Public Works has reviewed the above mentioned application and provides the following comments. The department has not issued an approval for a stormwater permit. The department has not issued a curb cut permit. The department does not maintain this portion of Munsell Street as a public way. It is currently located on private property." Next, we have a intra-office memorandum from Steve Williams, the town manager, that reads, dated August 19th, 2025, that reads, "The Select Board at its regularly scheduled meeting of Monday, August 18th, 2025, received and reviewed the above referenced application as submitted and encourages the Zoning Board of Appeals to support the recommendation of the Planning Board's decision, not grant the appeal and not overturn the Building Commissioner's denial of the building permit at the parcel on 240 Munsell Street." We have a memo dated August 6th, 2025, from the Board of Health that reads, "The Board of Health approved and issued septic and well permits to Mr. Berry in April 2023 for Munsell Street, map 214, lot 1. The septic system has not been installed as of this date, and the office has not received a well drilling report showing that a well has been drilled. The health office has no comments regarding the legality of the road frontage." And then we have a ZBA review memo from the Conservation Commission. The comments read, "If the work is done according to the submitted plan, this project requires permitting due to multiple resource areas from the Wetlands Protections Act and the Belchertown Wetlands bylaw located on this lot and surrounding lots. The applicant must submit a notice of intent or confer with the Conservation Department about other potential options. I am additionally going to read into the public record an email that I sent to the applicant, Robert Berry, on Thursday, July 24th, 2025. It reads, Mr. Berry, my name is Jennifer Sharrow, and I am the chair of the Belchertown Zoning Board of Appeals, ZBA. The ZBA is in receipt of your application dated July 10th, 2025, regarding the property known as 240 Munsell Street. I apologize for the delay in reaching out. The ZBA is still in the process of hiring a new secretary, which has resulted in some administrative delays in the processing of applications. There are additionally some administrative matters regarding your application. First, we are missing the certified abutters list, which must be requested and paid for by the applicant. See attached blank application package, boxed information on the bottom of page 2. Next, we need a certified plot plan. While there are copies of certified plans in the application materials, there is no plot plan with the information as required on the attached page 4. The blank application lays out the specific elements, but here is another good summary of what a plot plan is and what it does. A plot plan is a bird's eye view of the entire property. It is an architecture, surveyor, engineering, and/or landscape architecture plan, drawing, or diagram which shows all of the major features, buildings, and structures on a piece of property. It also shows abutting roads and the new proposed buildings or structures at a defined scale. Why do I need a plot plan? Plot plans are required for all exterior additions or new structures. The plot plan may be used during the zoning, variance, or building permit review process to help check for any conflicts. It aids in determining whether the proposed excavation, construction, moving, or alterations is in conformance with the development regulations in the town's zoning ordinance. A plot plan is used to plan new single-family and two-family residential construction and residential alterations such as decks or sheds. The measurements of the plot plan should be included in the proposed column on the attached page 6. Specifically, the issue seems to be the frontage, which is referenced in the June 10th, 2025 letter from the building commissioner. I say seems to be, as the application does not provide a narrative from you describing why relief should be granted. The ZBA needs as much information as possible in order to properly review the matter presented to us. You can separately attach a narrative, as there is no blank document specifically included for narratives for appeals from the building commissioner. Please complete the application in full. Upon receipt of a revised application, a hearing will be set. Please be advised that the purpose of this email is for informational purposes only. I cannot and will not provide advice on the merits of the application itself. This email does not constitute legal advice. This email addresses a public matter for the town of Belchertown and may be subject to public disclosure. In response to that email, I received a plan of lot for William D. Farmer III, which is dated July 18th, 1988. Additionally, Mr. Berry, the applicant, submitted to me a durable power of attorney for financial management in regards to having his father speak on his behalf at this meeting. Those are all the documents that have been submitted as part of the application. Everything has been read into record. Would anyone like to make a motion to open the public portion of the hearing?
I would like to make a motion to open the public portion of the meeting.
Second.
All in favor?
Aye.
Aye.
Great. We are opening the public portion of the meeting. Mr. Berry, if you would, please, address the board and let us know what's going on here.
I'm Richard Barry. I'm representing my son Robert Barry, who's the landowner. For the record, I'd like to state that I received none of the comments from any of the boards. I was supposed to receive a copy. I received a single thing you read into the minutes. So all of that's like news to me. Robert didn't receive it either. It would come to post office box 1, and I've checked the box every day for not just that, but other things. The issue here is the lots were created by the court. At the time they were created, there was a Munsell Street that was not apparently recognized as an accepted way in the town of Belchertown. However, the town had 20 days to appeal the judge's decision in granting those lots with the frontage. And they did not, which means that that's pretty settled law in Massachusetts, in that they're not gonna litigate that again. They've litigated it once. I got involved in this whole parcel, I don't know, about 10 years ago. I personally, along with a partner of mine, took over a subdivision that was in trouble, Oasis Drive. We completed everything that was required on that subdivision. Everything. The town planner, to this day, will insist that there was no Munsell Road, that whatever there was in the way of Munsell Road was absorbed into either half of it to the homeowners association and half remained with Peter Galuska and the development company. The problem is, the planning board had ordered that road be divided in half. Peter couldn't do that because he didn't own the road. The town did. And to this very day, I submitted documents, certified copies from the Registry of Deeds. Munsell Street or Munsell Road exists in its same format as when those lots were granted. Nothing has changed. There was a deed there from Mr. Farmer. Well, the Board of Selectmen at that time had a taking. They took the existing Munsell Street and a deed from Mr. Farmer to the town, specifically stating in the deed that it was for a construction of the road. I'm amazed because I spoke with the town administrator who said, gee, I didn't know that. Town planner didn't know that. That road is still in existence, even though it's not an accepted road. It is still in existence the same way it was when those lots were created. So, the frontage is still there. Nothing has changed on that piece of property, except the fact that that road still exists. Now, there's a lot of language in the earlier part of what you read that had to do with something that was submitted to the planning board for an A&R lot, just a couple of months ago, that they rejected. And, quite honestly, I looked at that and I could see why the planning board rejected it and called it a virtual frontage. Because on either side of that road are wetlands. And there are a couple of crossings, brook crossings. But that road has the culverts in it already. So there's no wetlands on the road itself. We, in an effort to satisfy the town, after speaking with the town planner and the building inspector, had a surveyor work with the town planner at a cost of $4,500, I might add, to come up with something that would be acceptable. They decided, meaning the town planner and the surveyor, that the best way to do it was, there was already that existing 50-foot right-of-way that had been given to the property in the back in the event they needed to use it. We ran the 50-foot strip right down the same thing, but gave it just a little bit of frontage to create an estate lot. That was rejected by the planning board on the basis that it just looks like you got it. You wouldn't be able to feasibly use that strip to come in and out of there. But it was all right for them to approve that, for the people in the back. I wonder how that is, how you can, on the one hand, say to somebody, they made us grant them an easement for that same 50 feet, okay, so that the back could move their logs out of there, okay, but good enough for them, but not good enough for us. So that's what the surveyor had come up with, and that's what he presented to the planning board. Really doesn't have anything to do with with the appeal of the frontage. The appeal for the frontage is based on the fact the lots were created by the court, not by the planning board. They were ordered to do that. The lots were created by the judge. Okay, they had 20 days to appeal. They did not. Okay, which means that they lost all of their rights to argue and relitigate that again. And the road, of which I gave you a plan that was submitted, we gave you a plan of the road that was submitted with the court order and with the taking of the property. So one of the smaller sheets. But the big issue here is everybody has forgotten that there's still a road there, that was never deeded away, it was never deeded to anybody else, sits there in the registry of deeds and says Munsell Street, while not an approved road, but for the purposes of what we got here, okay, is still in existence, and in fact, it is passable. I've been driving over it for a year, okay, with all kinds of vehicles, including a Cadillac. I don't have any problem running up and down there. That road's in fine condition. When we took it over, we had some upgrades done, not upgrades, but maintenance done on it, and ultimately, if we're going to use that again, we would do the same. But this is a lot, granted by the court, has the frontage. Nothing has changed from the time that the lot was granted by the court to this present day. Also, on the town map, they're listed as building lots. They've been taxed as individual building lots. When they passed, they didn't get passed with the big, he got those 2 lots well before the other bigger lot transferred to him from his mother. But so these were building lots that were bought and paid for, standing on their own. Passed title examiner, so maybe we get to an action against them. The fact is, what I'm asking is in all fairness, without access to that road, there is no way that those lots are viable building lots. We need to have the access back, the frontage back on the road, and we need to be able to continue the access to the road. I had that discussion with Mr. Williams today. In fact, we don't care if you ever build a road, but if you don't, give us back our 60 feet, and then we can go back to the planning board using the 60 feet and get an A&R lot out of it if we need to.
So I had a quick question for you.
Yeah.
To access this lot, I mean, you have 3 in a row, right? You got like the big one, an in-between lot, and then the lot that you're currently trying to build on that has that corridor, that 50-foot wide corridor back to
That's right.
Munsell Street.
Adjacent to that corridor is Munsell Street.
Right, that last 50 feet
That
touches Munsell Street.
What we submitted in that for the A&R lot to the planning board that was rejected was that same 50-foot easement right-of-way, okay, extended just a little further so that you can make it an estate lot on the approved road, okay? And without that, we have no access. And for that reason, if I appealed it to the court, I think the judge might see that, you know, the town pretty much blindsided us here. On the one hand, they're saying, we can't give it to you here on this 50-foot, but we're not going to let you use the road that's adjacent to that 50-foot. There's 2 inches between them.
So you aren't literally using that corridor to access this lot?
We are literally using that corridor to access lot 1.
Oh, okay.
And without it,
I thought,
there's no access.
wait, I'm sorry. So the map that's a little bit bigger, that's at the very end, what is this document? So it was the 2 pages, it was the big one at the end.
No, that's not the one, I know what you're talking
Yeah,
about.
but what is this? It's not dated, it's not noted what it is.
Oh,
I just like looking at it because it's
No,
bigger. I can
it's
see all the numbers
helpful,
and
but
stuff,
it documents
that was
something
the map that was
different
submitted to the planning board.
for the A and R.
Yeah, see this right here?
Yes, no, I understand what that is.
Yeah,
I just
that was
wanted
the easement,
to
and then the road is right
confirm.
here, it's right here.
And so do you use the road currently for access, or do you go into
No,
the
we use the
property
road.
for, okay, so the gravel, what's
Yep.
noted here as
Yeah, We
gravel.
used the gravel road. And at a cost of $63,000, we did all of the pavement, all the way up to Lucia's private road, and all of the engineering. And we paid for that.
But was that part of the Oasis project? Yeah,
Munsell
Which
Road, nevertheless,
was-
but that's, it's all the way down under here, when the Oasis Road is back here.
right,
So it was done all the way,
right.
all the way.
But, you know, so that's kind of, it is two things, the Oasis. Thank you for pointing, that out, for describing what that map is. So your position here, can you please confirm that you're saying that you are asking the zoning board to declare the gravel portion, what is documented on this last map, the gravel portion, a legal road, granting full frontage?
That road was in existence as it currently is when the court ordered those lots to be, you know.
Okay, can
Yeah,
you
go ahead.
just, is that what you're asking?
What I'm asking is that the frontage that was on Munsell Road be affirmed. I mean, it may not be what they call an accepted and approved way, but for the purposes of granting us our frontage, that's what the court did. The court did that. The court said, okay, the frontage is on Munsell Street. Now along comes the town, and they take Munsell Street, and it's deeded to them in a quitclaim deed for the express purposes of building a road. Now, they decide that that's too expensive for them, and that's okay, we understand that. That's too expensive for them, so we're not gonna do that, but you lose your frontage. Yet it still exists.
While we're talking about the court, Mr. Berry, so you are talking about the court said, and you mean the land court in the 1970 decision that was attached?
Yeah.
1974, 1975.
Yeah.
So there's a land court. Dated February 22nd, 1980.
Which one?
So the first one that's in there. And then also a land court dated April 25th, 1974.
The actual court order creating the lots came out, it looks like in, 75, 74.
Okay, so the one that reads the top number 01439
That's
above
it.
confirmation?
Yes.
Okay, yeah, the one I saw
It
1980
was created on 2/21/1980.
is when it was recorded.
And that's, specifically for lot 1.
So since we're talking about the court, you were a named party in the October 29th,
Only as an agent, I never owned any land there, ever. None of it. Not
so-
Oasis Drive, not this land, you know, how my name ended up in there. You know, I would have no standing if my name were in there, because I had no ownership at all.
Were you served and did you participate in the proceedings?
The only way I participated was in providing the very information I'm providing all of you to the lawyer. That's it. I never went anywhere. I never was deposed by anybody or.
Did
know.
you, I mean,
I didn't pay for anything. I wasn't the client. Marcel Nunes was.
but you are, let me pull up note 1.
He didn't represent me.
I don't have the full kind of case history in front of me. But it's, even if it didn't involve you, you were named, and this decision, this is one of the attachments that was
But
included.
that, I'm not the one bringing this action. I'm just here talking today. My son owns this land.
Okay,
So he'll bring his own actions pending what happens
but
here.
we're talking about court cases that govern this parcel of land. 2 of which were submitted from the land court by your son as part of the application.
No, he wasn't part of those. Those are previous.
Oh, yes, but I meant he submitted them.
Oh, yeah,
he
right,
did.
yeah.
And then
we
this-
submitted them because it all begins with the court case. It all begins with the court awarding the lots.
But so there's this land court 1975 recorded in 1980, land court dated April 25th, 1974. This is a mass appeals court case from 2019. Where does that date come from? The action commenced in the Superior Court, so it was in the lower court first, in 2015, and it was regarding an A&R plan.
That has nothing to do with us.
It is for, there was an A&R plan. So I'm going to read from the appeals court case that states, on January 23rd, 2015, Richard Berry filed with the Planning Board of Belchertown an application seeking an A&R endorsement pursuant to GL Chapter 41, Section 81P.
I didn't send anything to anybody.
The accompanying plan showed 2 lots, lots A and B, each with 140
I
feet
submitted
on
nothing.
frontage.
Nothing. I don't know what that's all about. That's not from me. I have had no legal action at all relative to the Oasis development or. Well, I'd like to see a copy of it because that would be the first time I've seen it.
Would it be your son?
What's that?
Would it be your son then?
No, my son didn't get involved in this until he got did these building lots a couple of years ago.
Oh, okay.
Yeah.
That was from 2019?
This is
Correct.
from
Who's the lawyer on it? Ms. Sharrow?
2019 because it specifically addresses this plot of land. So if you're not aware of
I'm not aware of it. I never submitted anything to the planning board.
in 2015,
Only thing I did with the planning board was when they required the as-built for Oasis Drive and the ownership property, I coordinated that with a surveyor, but that's the only time I've been to the planning board. And this last time, my son filed this one.
the court case is important because my reading of it purports to overturn the land court decisions submitted here by you, by the applicant. And without you being aware of this, it's extremely important information for you to have.
My signature appear anywhere there?
This is it's a publicly available document. It's not
Oh.
submitted, so it's the judge's decision.
There were
I
not-
mean, your
there haven't been any
your
judge's
name.
decisions on my behalf or anybody's behalf.
And there are publicly available, the Superior Court submittals, which I glanced at, but didn't confirm, I just looked at them to see, just for curiosity. I don't feel comfortable of you not having knowledge of this case and
I
its
don't. I really don't.
impact on these plots of land.
Does it list plaintiffs and defendants?
You are a listed party, Richard G. Berry, and another who is
And
Mr.
Marcel
Nunes.
Nuns.
Yes.
Marcel Nuns, it was the only owner of that property. And I was an agent for Marcel. I did a lot of things for Marcel, not just in this, but all kinds of things. He was the kind of guy that, we did things together, and he threw the money up and I did the work.
I don't, because this decision specifically has an impact regarding
What was the
these
decision?
parcels of land. I will read from the case. Let me find something that.
I mean, what was even the case about?
It was regarding what I believe to be these parcels of land and whether Munsell Street in that section is a public way.
Well, I don't think there's any argument at all that it wasn't a public way.
Well,
Ever.
it was-
Even in the beginning, the master made a mistake, but the town was supposed to appeal it. And if they appealed it, they would have been able to preserve their rights. But they didn't appeal it within the 20 days, and so it became the order of the
So
court.
the court talks about this theory called estoppel, which would a collateral estoppel, which would, where a previous decision of a court
Right.
would mean that they're stopped from trying, like, that's it, that's
That's right.
final. The court said that's not applicable here.
They said it's not applicable here,
That,
but it certainly didn't have anything to do with the frontage to those lots or anything. And the fact of the matter is that the road is still there, and the land is still there. It's right there, and it's still owned by the town. And the town is gonna build me a road if it has to.
I cannot overrule a appellate court decision, and I feel like you having a full understanding of what was decided by the appeals
I
court.
have no idea. This is the first I hear about this thing. I don't even know about a decision. And if I wasn't sitting here tonight and Robert was sitting here, he'd look at it, his eyes would cross. He'd say, I don't know anything about that. All I know is I bought building lots that had frontage on Munsell Street, and that there was a court decision based on that. Going forward, it isn't me appealing anything. It's him and his lawyers.
So, there is an option to continue this hearing so that you and your son can have all of the information in front of you, so that we're all on the same page, about what's going on here, because I wouldn't want to, I cannot ask you questions regarding this appeals court decision that might impact the current application where you don't know what I'm talking about. That's not,
I really
that's
don't.
not
I
fair
don't know a thing about
in
it.
any way.
So it may be, I can talk to Munsell, his name's on there. It may be that he said to the attorney or somebody, if you need any paperwork, or you need any of this, contact Richard Barry, and the guy put my name on there. But I had no standing to sue anybody. It wasn't my land. It wasn't my road.
You said your son only came into ownership of the land a couple years ago?
Yeah, he bought these from Munsell.
And then before that, so in 2015,
No.
it was only Marcel who was an owner?
It was owned by Munsell.
I don't know. I don't know what happened prior to this. I only have the information that's in front of me. And what's in front of me is this appeals court decision, which means there's all sorts of information and records from the Superior Court. It looks like the attorney for the plaintiffs was Bacon Wilson,
Okay.
which is a reputable firm
Yeah, they
in
are.
Springfield. And then, so then we have notes from the planning board that were submitted since the planning board was the other side of the party in this lawsuit, and then the easement agreement. So there's really important things in here. And I don't know if I can. I would recommend a continuance. I don't know if I'm in town next month. Are we the third? What's the third Wednesday? Which I will be out of town for the third Wednesday, so we won't have a quorum, which would push it to October.
Do a continuance.
Do you have an attorney's name in there?
The attorney on the civil action is Ryan O'Hara.
Ryan O'Hara.
Mm-hmm.
Okay.
He's in the Northampton office.
I'll look through the records and Mr. O'Hara will
So
get a phone
we
call.
can give you a copy of these that was submitted today. So would you, okay, so the action, we want to confirm that it's in,
I don't even know what the decision is and why,
I know.
why it's
It's-
important to this.
it is very important to this.
Okay.
And I do not feel comfortable moving forward without you having a full understanding of what the courts have decided regarding the land question here. So, right?
I agree.
Is this, I just want to make
Yeah,
sure I'm
but-
not
Yeah,
now
so-
being,
I'm being asked about something I don't even know anything
Exactly,
about.
exactly. So, is that something that you were,
Oh, yeah, I definitely would do that. Yeah,
Yeah.
it makes sense.
okay.
do we need to vote on that? Approve the continuance?
Yeah, let's make a motion
Okay.
to a continuance to 1, 2, 3.
So documents were submitted to the court with my name on it.
Yes, sir, Richard
results
G.
from the-
Barry.
Right.
I didn't even have a lawyer. Marcel Nunes is the name on that?
Yes, he is the other
Okay, so-
party.
He is the what?
Is the
Other party. There are two parties.
He's definitely the only party. And he paid for it.
Should I make a motion?
Yes.
Okay, I would like to make a motion to have this hearing continuance till October
15th?
15th of this year.
Are you available?
I second that.
All in favor?
Aye.
Okay, so we are going to, I'm gonna provide you a copy with the documents
that'd
that
be
were
great.
submitted from the planning board, including the letter, their notes that they submitted to the town, back in 2017 regarding this.
Yep.
A copy of the decision. This is publicly available online. You can also go to Mass Courts and look up the previous one, but you're gonna wanna follow up with the attorney
Well, I'll
and
call
Mr.
O'Hara. He can
Nunes.
count on that. Get it from him.
And then also attached is that easement agreement. So there, I'm gonna give you this because I have my own copy for the official record.
Yep.
And then we'll kind of circle back because I think it's really important information that you're gonna want to be able to address.
Okay.
We never closed the public portion, but
Well, we were still getting
We're
info
still-
from public,
yeah.
so,
yeah.
I make a motion to
I guess,
close.
wait, I mean, there's
Okay.
other individuals here before we kind of move on, if there's anything about what we've talked about so far, unless you'd like to join us at the continuance.
I would like to add something.
Okay, who are you, where do you live?
My name is Anna Drost. I'm representing the Oasis Homeowners Association.
Okay,
So we are the abutters, and our concern is that this road goes on to the Homeowners Association property. So that's our concern, and obviously this land has been set aside for the Homeowners Association. We wouldn't want the road running on it.
okay. We'll make note of that. Okay, so then with that, thank you. Would anyone like to make a motion to close the public portion of the meeting? Yeah.
I make a motion to close the public commentary on this matter.
Okay,
I second.
we'll take that. Public portion is now done. We have some administrative stuff, but we won't, like, there's nothing else. You can stick around or go.
We
Or
all
just,
set?
yes, you are all set.
October 15th.
This is for you.
Oh, that's me, thanks.
This is for
You
you.
got a little,
I have my
do
own.
we get any more correspondence from, relative to the 15th? Is it gonna be sent?
Yes, you will get, there'll be another notice. There'll be another notice of the hearing, so,
Sounds good.
yes. And then the only other thing on our agenda tonight are to approve the meeting minutes from March 19th, 2025, which was for a special permit. Would you like to make a motion to approve?
I make a motion to approve these minutes of the, March 19th, 2025 meeting.
Thank you.
I approve.
Second, okay, all in favor?
Aye.
All right, that is everything on the agenda tonight. We are all done with the ZBA meeting this evening.
You go to adjourn?
We're adjourned. We're done. Is that not sufficient? We have to say adjourned.